Hi, I'm Tristan. This is Thinking About Politics, and today we're thinking about a Supreme Court case we heard about that might toss as many as 100,000 ballots in the trash in one of 2020's most important swing states. With an election only days away, this decision is either something that will throw the election into utter chaos or the only thing preventing it from it. All depends on where you get your news. And with one candidate vowing to contest the results of this year's election and the Supreme Court getting such coverage, that's really got us thinking. So the other day I heard about this case. Boy, was I interested. In Democratic National Committee versus Wisconsin State Legislature, the Supreme Court overruled a district court decision granting a 6-day grace period to receive ballots in Wisconsin. State law mandated that ballots received after Election Day could not be counted. However, due to evidence that mail was being delayed, that the COVID-19 pandemic was threatening the safe and normal operation of elections, such as that adherence to the pre-existing deadline would have resulted in the disenfranchisement of as many as 5% of the votes cast. Finding that there was about a 6-day delay in the mail, the judge created a 6-day grace period through which ballots could be received. Like most other things these days, I expected the reporting on this case to vary with one's ideological lens. But whatever your partisan filter, it's important we really dig into the facts here and see what was decided and what wasn't. And importantly, why the court reached this decision. But before we dive into all that, let's take a look at the flag and, wowie, there's a lot going on here. You know, I feel like if I break down all the elements here, you got a lot going against you, Wisconsin. Well, I mean, the color scheme's a bit, it's all over the place, isn't it? And there's a lot of detail. I don't understand how you expect any little Wisconsinonian, Wisconsinite, Wisconsinonian. We're going to go with Wisconsinite. I don't understand how you expect any little Wisconsinite to draw that. You even put Latin on a flag. Flags are no place to be showing off your Latin. But you know what? When you throw it all together, it kind of works. It's almost like the Where's Waldo of flags, almost. It's just bonkers. It's a bonkers flag, but it works. They even got grapes in the cornucopia. Do grapes grow in Wisconsin? Is Wisconsin known for its grapes? It shouldn't work, but it does. Sorry, North Dakota. You're being bumped to number 4. Wisconsin, you're our new number 3. Well done. Now let's get back to the task at hand. On October 26, 2020, the U.S. Supreme Court issued its decision in the Democratic National Committee versus Wisconsin State Legislature. So what's the issue here? A lot of times, you'll find your answer depends a lot on how you frame the question or look at the issue. For instance, in one way to view this, Wisconsin as a state set a deadline. That deadline was based on every consideration a legislature would likely consider. Why does a federal judge get to decide that their determination should overrule the state's determination? Where does that judge get off? For the justices in the majority, the district court's reasoning was a flimsy one. Judge Gorsuch framed the issue this way. Because of the current pandemic, the district court suggested it was free to substitute its own election deadline for the state's. And when you say it that way, well, yeah, that makes sense. Sure. The argument here is that the legislature has not done enough, but who's to say? Who's a judge to pass judgment? Now, state legislatures get to set this rule, so why ought that deference be overcome? The majority opinion is all about deference. Ironically, Gorsuch writes, so it's indisputable that Wisconsin has made considerable efforts to accommodate early voting and respond to COVID. The district court's only possible complaint is that the state hasn't done enough. But how much is enough? I kind of feel like Gorsuch's reasoning here is highly legalistic and very idealized. It's not that it's wrong as an abstract matter. Yes, I expect legislatures to set rules and generally set rules for elections, but the suggestion that the only check for the whims of a legislature are periodic elections is just wrong-headed. The judiciary has long served a function of checking legislatures, especially in the realm of elections. Justice Kavanaugh's concurrence largely concurs with Gorsuch's analysis. He says that, quote, federal judges do not possess special expertise or competence about how best to balance the cost and benefits of potential policy responses to the pandemic, including with respect to elections. But Justice Kavanaugh goes even further. He says that voting by mail is, quote, really easy. He knows this because the governor said so once. He says that voting in person is reasonably safe. Therefore, voting in person is a valid option. Says that elections must have deadlines. Well, of course they do. But he suggests that those who miss the deadline in this case have only themselves to blame. There doesn't seem to be any willingness to appreciate the gravity of the situation. No, that responsibility, which the Supreme Court surely has, I think, is shirked. They're saying, no, we're not going to accept that responsibility. We're going to push that off to a state legislature. They have to consider that. That's not something we don't consider ourselves with reality. God, no. Justice Kavanaugh's concurrence largely says that those who don't get their ballot in on time don't deserve to have their vote counted. The right of the rest of us to be able to hear the election called on the news overcomes the right of those voters to have their votes counted. That's harsh, but yeah, hey man, I'm just going to say it. If voting by mail is really easy, if it's reasonably safe, yeah, I think Justice Gorsuch and Justice Kavanaugh have a point. Yeah, what? I said it. Where does some federal judge get the power to overturn a state election deadline? That didn't make any sense at all. But remember what I said in the beginning about how we frame the question and how we frame the issue? If the facts are, as Justice Gorsuch and Justice Kavanaugh say, if the deadline set by the Wisconsin legislature is a deliberate date set to best balance equities and not, the result of a lazy legislature, or worse, then yeah. But how do we know what the facts are? Quick diversion real quick. You know what's really fascinating? How courts are set up. Like how different levels of courts really worry about different things. You ever think about how courts decide what facts are? I mean, if you change the facts slightly in any given case, change them just a little bit, you'll change the legal outcome. So how do you prevent one judge from interpreting the evidence one way and another judge from interpreting the evidence another way and reaching a different factual conclusion? You don't. At the trial court level, that judge is responsible for taking in all the evidence that needs to come in to hear a case, to prove the facts of a controversy. Sometimes parties disagree about what the facts are. Generally, a jury will decide those unless they're certified to a judge, and sometimes the parties will agree to the facts. They just disagree about what they mean legally. All the facts are generally supposed to come in at that trial court level. According to the trial court judge, the undisputed record, the factual record, demonstrated that adherence to the state deadline here was going to result in the disenfranchisement of voters. Now, I'm no Perry Mason, but I think the right to vote is one of their constitutional rights that's protected. So what do courts do when a state law conflicts with a constitutional right? Here, the state law was this deadline for absentee ballots, and the right at issue was the right to have a ballot that you cast count. So that district court judge, who is a lot closer to the situation than I was, I don't know what the facts are. Justice Gorsuch, Justice Kavanaugh, you don't know what the facts are either. But the district court judge made factual determinations and found that the record showed there would be disenfranchisement. Here, the judge determined that the appropriate remedy was merely a 6-day grace period. A 6-day grace period fashioned on a grace period granted in past elections, which was tailored to the delay they found in the postal service that would affect these ballots. This wasn't an arbitrary time limit. This was based on something. All right, real talk for a second. Reasonable minds can disagree. As an abstract academic question, I think Justices Gorsuch and Kavanaugh raise a pretty interesting question. And also Justice Roberts, who, by the way, only decided the way he decided because it was a federal court judge as opposed to a state court judge. Very similar case coming out of Pennsylvania. He came out the opposite direction because the judge was a state court judge and not a federal court judge. Really interesting academic points. Why should some federal judge be allowed to overrule a state deadline here? The quick answer might be that judges get to invalidate laws all the time that infringe on constitutional rights, or order whatever other relief is fair and equitable under the circumstances. A 6-day grace period was all that was mandated here to cure what the district court found to be a constitutional violation. But again, all of this seems pretty distant and academic when compared to the practical problems all around us right now. Honestly, the danger here is that this decision does more to fan the flames of distrust in the results of this election than it does to quell anything. It's worth remembering here that the judicial branch is the weakest of the three branches of government. The legislature gets all the money, the president, the executive, gets all the guys with the guns. All the Supreme Court has at the end of the day is this, a couple of these, and the creative use of the English language. Unconvincing opinions do so much harm to the court's standing. At the end of the day, I guess I'm just left scratching my head and wondering if Justice Kavanaugh or Gorsuch really deferred to the facts that this district court judge found. I mean, they say they do, but they don't really engage with them at all or talk about what they mean. The dissent carefully walked through the facts that the district court found troubling and the issues that were confronting the Wisconsin election here. The danger is that up to 5% of the election might be discounted, not because people are lazy, not because people didn't follow the rules, but because this is a pandemic. It is an unprecedented situation. It's hard to plan for. It's hard to know what you're supposed to do. And to hold people to such a high standard when they're just trying to exercise their basic right to vote, well, it just seems mean to me. And if you're going to do it, you got to have a good reason. And the Supreme Court, you did not convince me this time. So take that for what it's worth, Supreme Court. I'm sure you're keeping score at home. Anyway, that's all for now. I'll throw some links in the description. Read this case. Read Justice Sotomayor's dissent. There's a lot to talk about in this case. And really, I just wanted to point out that our court system can only function when we defer to the factual judgments of our trial courts. We can't spend our days trying to figure out what reality is in each and every hearing. We need to rely on that factual record that is built at the lower court level. I really don't get the sense that the facts mattered at all in this decision. It's kind of an after-the-fact consideration that, oh yeah, things are bad, but legislatures can, do stuff. And that seems like a shallow analysis to me. And if it seems like a shallow analysis to me, you're in trouble because I'm a big dummy. Anyway, that's all I got for now. Till next time, keep thinking.